Adjournment request, if any, from item number 1 to 6.
May I please, Your Lordship, I beg to mention item number 1.
Hmm.
I've taken the consent from the other side, Lordship. Much obliged.
May I please, Your Lordship? My Lord, I beg to mention item number 5, Lordship.
5. Yeah.
40, Lordship. Obliged.
In respect of item, in respect of item number 6, I have filed an additional affidavit that may kindly be called for, my lord.
On behalf of whom?
On behalf of respondent number 4.
Respondent to Das. That regarding your.
Yes, my lord. That has been filed yesterday. That may be called for, my lord.
May I please, Your Lordship? Lordship, my prayer for listing a writ petition, Your Lordship, on
Ask the registry. Ask them.
adjournment request from item number 7 to 14.
May I please, Your Lordship? My lord, I am seeking adjournment for item number 9, Lordship. Perhaps, my lord, we may withdraw the case, my lord. In when instruction is awaited.
Last time also you
Lord.
time for this.
Lordship.
Apparently it's less than 2 crore.
Yes, Lordship. Otherwise, it's below the threshold limit, my lord.
Then what means?
My lord. Only thing, my lord, we have
Letting me that the question of law will be open
Lord.
in any other case.
Lord.
Orders came and shut.
Lord.
There are some orders. We have already passed. Let the number come.
Lord.
Some orders are, we have already passed some orders.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 13 and 14 of the daily list. Lordship, we are seeking adjournment in the matter as we are being led by the learned ASGI. He is before the Supreme Court. There's a part heard matter which is expected to take the entire day, Lordships.
So Das is not appearing in this matter.
Lordship, we are from the same office.
Yes. What I can say. Same here. What we can say.
Let it go a little far, my lord, because otherwise every time.
Lordship,
Yeah,
can we have it in the month of May on the 18th?
August. Now all the matters will be listed in August. If you don't have any urgency today, then certainly in May also you don't have any urgency.
Lordship, we had an urgency. It's just that
Okay, then on
there's some
August,
difficulty.
Even though if you have urgency, now seeking adjournment, August. Yes, sir.
Much obliged.
May I please, Your Lordship, I beg to mention item number 8.
Yes,
I am appearing for the appellant, Lordship.
August.
Lordship, can it be taken on 20th of May?
No. Will be
Lordship, we have
listed
some
in
urgency, Lordship.
August only.
We are for the appellant. They are
You
seeking,
are for the appellant, if you have given the consent, then it will go in August.
Lordship, consent.
That's it.
There's some urgency, Lordship. It's a refund matter.
Whatever it may be, August. Yes.
Any other request? Daily list for hearing item 2.
Please, Lordship. Basically, in this PL, my lord, the extension of the Assam State Capital Region 2017, my lord, act has been, my lord, challenged, my lord, not to extend the scheduled tribe area, which are, my lord, protected by Chapter 10 of the Assam Land Revenue Regulation, my lord. And, my lord, Section 160 to 65, my lord. So that is under silence, my lord. Lordship,
Still something, the persons whose lands were acquired, they were paid compensation, they have happily received that compensation. everything, the land is handed over to the concern. What remains in this petition
But
now?
in that case, my lord, regarding my lord, using of the my lord urgency clause, section 40 of the my lord act, my lord. That is my lord, there is no urgency, my lord.
No urgency, the government is saying we have urgency in this
My
matter.
lord, suppose my lord, they have acquired, they have established my lord camp, my lord, whatever it is, my lord. If court does not intervene, make an observation, my lord, in future they will do that, my lord.
Sir,
In that
okay,
area.
anticipate
my
in
lord-
future, in every case, they'll invoke section 40, sir. It would be.
My lord, my learned pin may, my lord, aware of this, I am not aware of this fact, my lord, whether they have, my lord, they constructed the, my lord, that.
So whatever it may be, the land, possession of the land acquired was already handed over to the Assam Rifles. And the persons, 26 persons whose land was acquired, they were paid compensation and they have not raised any objection.
My lord, if we see the list, my lord, of the who are getting compensation, most of the people are, my lord, they are not the owner of the land, my lord.
So that is altogether a
That is
different thing.
different thing, my lord. Don't not
That-
understand
And that
because,
is not your plea in this
My
PIL petition.
my lord, not,
That is not
be-
your plea.
not my plea, my lord. Because the as per the, my lord, the act, my lord, 2013, my lord, who have any interest on land, they are claiming that amount only interest on land. They are not the owner of the
Sir,
land.
this
Owner
is
of the
not-
lands are the tribal people.
Basically, this is not under challenge, sir.
That is not under challenge, my lord.
Then
Because
how
that-
can we adjudicate at this point of time, sir?
My lord, except this, my lord, the extension of the east, my lord, the act, my lord, is,
Sir, your basic grievance before is that why they have invoked this section 40.
that is
This is
what,
what-
my lord, the
this is
second
what-
prayer, my lord.
And in reply, they have said, "Okay, for the security reasons and many other reasons, we find that it's an urgent matter and they have invoked that provision."
My lord, section 41, I have to look into, my lord, before using the section 40, my lord. Let's see, come to the, my lord, the Assam.
And you have not even filed counter to the reply, sir.
This is a legal point, my lord. They are saying,
Legal point, but ultimately it's purely an academic exercise when the acquisition is completed in all manner. The land was handed over to them. Compensation was paid. The persons whose land has been acquired, they have not raised any objection. Why this PIL, sir?
my lord, this is arbitrary power. They have exercised, my lord, section 40, my lord.
Ultimately, the persons whose land has been acquired, they have to come before this court, sir.
No, this is, my lord, it is a PIL, my lord, not the, my lord, petition, my lord.
That's why
Individual
only the
capacity, my
PIL
lord, is a representative
Now-
capacity, my lord,
Go through the rules of the PIL.
my lord,
The persons who are directly affected,
my lord.
they have not approached the court. And you have not given any reason why they have not approached the court.
My lord, we are saying that we are the permanent resident of the, my lord, the
You may be
Timuria
the permanent resident, but
tribal
if
development, we have
other
it as
permanent resident of the area don't have any objection for acquisition. of
objections to be raised, lordship. I have lots of representatives, 6, 7
So
representatives there, my lord,
26 persons,
my lord.
the 26 persons whose land has been acquired,
My lord.
they have not raised any objection. They have happily accepted their compensation.
Because they are by virtue of agreement of purchase, my lord, agreement, my lord, for purchase, by virtue they are become interested on land. They are getting money. They are not, cannot purchase the land in but that area, my lord, because that is a civil tribe.
That is altogether a different question.
That is, I am not raising, my lord. That is,
You
I
are
am not raising.
Not raising them, certainly, sir.
Only I am, my question is, my lord, they cannot apply the section 40, my lord, without the
Now.
environmental
ultimately-
impact assessment report, my lord.
If we come to this conclusion, okay, yes, they have wrongly applied, then again the land will be given to those persons
My lord,
who
suppose,
have received the compensation.
my lord, suppose, my lord, in this case, court has upheld that their my lord, acquisition by virtue of my effects of time, my lord.
Why you are inviting?
If
the
court does
order
not
from the
intervene, in
court,
future,
sir?
they will do that, my lord,
In a-
because
in a-
this will
in a
become a precedent, my
appropriate
lord.
case- In a appropriate.
This will
case-
become a precedent.
In a appropriate, why you are inviting the observations of the court, sir? That this is right or this is wrong. Once it is purely an academic exercise, what remains in this?
Lordship may read then, my lord, let me read the section 40, my lord.
Okay, read.
My lord. The special
Be
power,
ready for this.
my lord,
And we are going to make an observation that this is ultimately, you are not a registered society.
that is true.
You are not a registered society. A group of persons have challenged this. The persons who are aggrieved are not before this court. And prima facie, we are of opinion that whatever your attempt is not bona fide. Now be ready for that. You may argue. You consider your arguments, but be ready for that.
my lord. Then, my lord, I'll file counter, my lordship, pardon
No,
me.
there is no question of filing. of
Because, my
counter
lord,
at
this is a
present now,
legal
sir.
point, my lord, that's why I have not filed
Because
counter.
pending
Factual part,
since
I am not
last 5
disputing.
years.
Factual part, I am not disputing except the using of the urgency clause, my lord.
Whatever it may be, you argue that first.
My
Then we'll have to make some observations regarding your bona fide also.
my lord.
Yes.
Lordship, that right to fair compensation transparency land acquisition rebellion, my lord, that.
Now, first of all, you show your bona fides. It's a PIL, show your bona fides.
Lordship may come to then paragraph 8 of my lord.
Yes,
Petition.
done.
So, Lord, sorry, Lordship, paragraph 3, my lord.
Paragraph 3.
3. Maybe from 2, my lord. That the petitioner being the member of the indigenous scheduled tribe, paragraph 2, my lord, of the district of Kamrup, Assam, being the social worker and member of a social minded organization who are,
Which social minded organizations whom you are the members?
my lord, Amri Karbi Development Council,
Which is social organization?
my lord.
Social minded organization, which are those organizations? Where is the details of those organizations?
No, my lord, in the representation, my lord, so many organizations is there, that's why I'm saying, but in the representation, my lord, the Amri Karbi Development
You are
Society
the-
is
you
there,
are
my
the
lord, Amri
signatory-
Karbi Student
you are-
Union is
you
there,
are
my lord,
signatory of the representations?
my lord,
You are the signatory of the representation?
my lord,
Okay. Social minded organization, read these paras.
my lord. Organization who are being conscious and vigilant regarding the rights granted under the Constitution of India and certain beneficial law and thereunder. The petitioner have made necessary inquiries and after collection of the documents and the verification of the same, they were convinced that the source of knowledge of the fact alleged thereunder are true. The petitioner had also made many representations to the authorities regarding their grievance, but there has no positive outcome till that. Therefore, they have approached the honorable court with their grievance in the public interest. 3. The
Yes.
petitioner stated that relief sought for this by this from this honorable court in the instant public interest litigation is for the bona fide benefit of the protected class of communities like the indigenous scheduled tribe, like the scheduled caste and other backward classes residing within the jurisdiction of the notified tribal bell and block of Kamrup M district in particular, and the scheduled tribe, scheduled caste and other backward classes having their place of residence in the various tribal valleys of block of Assam. The state revenue, the state revenue department of Assam is callous and unsystematic to the grievance of the scheduled tribe, scheduled caste and backward classes of the various tribal valley and block of the Kamrup M district, in particular, and notified tribal areas of the other district, pertaining to issue of their land, which is a age-old problem. The ignorance of poor agrarian tribal folk about their rights and the non-implementation of the protective measure laid down by the laws has also led to the encroachment of their ancestral land by the non-tribal and unprotected classes of people. Here, my lord, I am not only including that only tribal, these protected classes of the, my lord, areas, my lord.
Where is the pleadings that there is a complete ban in acquiring this land? Where is the pleading? Which is the provision which you are referring to? That there is a complete ban, it can't be touched. Where is the pleadings in the PIL petition?
My lord, I have
Where is the
referred,
pleadings
I
in
have
it?
referred section 160 of the, my lord, Assam land regulation, my lord.
Complete ban is there?
No complete ban is there,
Then-
but there, my lord, complete not ban is not there, my lord.
Then-
But there is a some policy they have to follow, there is a guideline they have to follow. Even my lord, new education
which-
policy of 2019, my lord,
provision of the-
there is a prohibition, my lord.
Which provision of the policy they have not followed?
That my lord will come through Assam land and revenue, my lord.
No, you just show it from the pleadings.
My lord.
Show us from the pleadings.
My lord, paragraph 8, my lord. I have elaborately stated, my lord. The genesis of the tribal bell and block, paragraph, page 11, my lord. The genesis of the tribal barren block dates back to the British rule. It is an established fact that the British had encouraged migration of the export cultivator from the then Bengal of Assam to Assam, with a sole motive to increase production and revenue. This partially has its impact on the ethnic and social milieu of Assam. And in 1930, in order to maintain law and order, the British administration had to restrain the land hungry immigrants by delimiting certain areas as close to the immigrants. As imaginary lines were drawn to delimit those close areas, this system became popularly known as line system, my lord.
We are grateful.
No, that way we're coming back because how it is protected, those people, how it protects the history, my lord.
Sir, what is the provision of the law? This is the history, yes. We are grateful that you,
Then Lordship, in the same paragraph, Lordship may come to paragraph 12,
12,
page 12. Same paragraph, but
page 12.
page 12. The Constitution, bail and block,
This is the history, we are.
my lord. Then Lordship may take paragraph 13, silent feature of the chapter 10 of the Assam Land and Revenue Regulation 1986. Now Lordship may come to the, my lord, administration of chapter 10, my lord,
Yes,
page 14. Then, my lord, 15, my lord, you got denotification of tribal debt, because there should be a denotification, my lord. Two,
earlier also denotification.
there is no denotification. We are not pressing the denotification. They will issue tomorrow, they look at that is different thing. But in fact, the denotification is required. When the tribal block is to be come under the purview of, my lord, GMD, GMCA, my lord, that notification is required. I am not pressing that notification, you issue the notification required, I am not on that. But initially, notification is required, my lord.
You're not pressing and required.
Well, because when the Guwahati was, my lord, become a, my lord, municipal corporation in 1969, my lord, this area was except Pan Bazaar and Portal Bazaar, rest above the tribal balance block, my lord, South tribal black block. They have issued the notification, that is Annexure 1, my lord. They notified, my lord. Thereafter, it became a Guwahati, my lord, Guwahati Municipal Corporation, my lord. Now, 1985, my lord, Guwahati Development Authority, my lord. So, Development Authority and Act of 2000 is want to extend to the Sonapur area, my lord, where the Bermuda tribal block of Bell and blocking existing, my lord. That is, though it is in a Guwahati, my lord, metro area, but the municipal corporation has not been extended to there, my lord. By this Act of 2017, my lord, the 4 district has been included in the greater, my lord, capital region area, my lord. So if capital region is gone, my lord, they have to develop those area according to the, my lord, plan and estimate of the, my lord, whatever it is. So if they develop, my lord, section 33 is a betterment tax, my lord. So if betterment tax is coming, my lord, the tribal people, the other, my lord, protected people of the well, they have to sold out the land. Because who the cultivator, he become a land of the town land. When the betterment tax is coming according to the development, they would not be able to pay, my lord. They would not be able to pay, my lord. So may come to Annexure 1, my lord. This is my first notification, my lord. The Guwahati,
Yes, sir, where is the requirement of issuance of notification at present? Show us.
that's why I'm coming, my lord. This is a PL, public interest is required. This is not my private interest, my lord. There is a specific violation of, my lord, something, my lord. We have to understand the problem of the people, my lord.
So the people whose land has been acquired, they have not come before this court and you are raising that they are facing the problem. They happily give their land, they gave their land and get the.
Then also, I may permit to then file an additional affidavit, my lord. I'll bring you all those records, my lord.
No, sir, there is no need. Now it's the hearing matter, sir. The additional affidavit, the affidavit was filed way back in the year 2022, 21. And now you are asking, I may be permitted. This can
This is a legal point. I, my lord, thought that, my lord, may not be required, my lord.
Yes, then may not be required, then it's okay.
Lordship may come to, my lord. Kindly bear with me, my lord.
Sir, we are hearing you only.
Oh, my lord. Let me, my lord, highlight those provisions in the, my lord, documents and law, my lord. State way I cannot say that I don't have a case, my lord. I don't have an interest, my lord.
Yes.
Personal interest. It's a public interest, my lord. I have to establish my public interest, my lord. This is, my lord, notification, my lord, dated Shillong, 30 June, July 269. My lord, this area of the South Kamno tribal block has been denotified. My lord.
Yes.
My lord. Lots of bioware, my lord, the Guwahati has been, my lord, the municipal corporation will come into existence, my lord. Thereafter, my lord, this is the, my lord, presently, my lord, this is the second notification, my lord, government as on 1990, my lord, this is the tribal balance block, my lord. So in case of, my lord, this lordship may come for page 41, they Kamrup, serial number 7.
Yes.
The South Kamrup, my lord, Guwahati tribal black, ball black created in 1950. Now Sonapur Circle, Sondrapur Circle, Polasbari Circle. I am on my Sonapur Circle, my lord.
Yes.
The Dimuria tribal development block, my lord. So thereafter, my lord, this is the notification, my lord, Annexure 3, what a zooming planning, my lord. Where this, my lord, action is to be prohibited, where, what can do, my lord. If we see, my lord, lordship, that there is a the greater Guwahati, my lord, they have extended to these areas, my lord.
Yes.
My lord, this Moza is there, my lord, Sila, Sindri Bapu, Bangsor, Beltola, Ulubari, my lord, these are the area they have extended. There's a description of new area, my lord. Here, my lord, they have extended to these areas also, my lord. Thereafter, my lord, according to this, my lord, the zooming regulation, my lord, lordship may come to page 47, my lord.
Yes.
Classification of land and uses of zones, my lord.
Yes.
My lord, here zone has been categorized, my lord, residential zone, commercial zone, industrial zone, public, semi-public, facility zone, transport and communication zone, and green belt zone, recreation and open space, eco-sensitive zone, eco-friendly zone. These 6 and 7, my lord, I am, my lord, pressing, my lord. So these are applicable in case of, my lord, this scheduled tribe area or the block and area or the, my under Sonapur Revenue Circle. Here, my lord, some activities prohibited, my lord. Lordship may come to the, my lord, bird sanctuary, my lord. So Amsung bird sanctuary, my lord, which is notified in 2017, my lord. That is within the, my lord, those area, my lord. So some activities is prohibited, my lord. Some activities prohibited, my lord. So the bird sanctuary, there is a wildlife bird sanctuary, my Amsung, this is within that area, my lord. It extends to Gorbanga, my lord. Osguwahati side also, my lord. Lordship may the G and E stand for, my lord, green belt and eco-sensitive zone, my lord. So bird sanctuary, this is a, my lord, eco-sensitive zone and green belt, my lord. The botanical garden is a, my lord, green belt area, my lord. So these are the green belt area, my lord. If the GMC authority has been extended to there also, my lord, these are not applicable, my lord. They cannot do something which might, in case of, my lord, the municipal corporation or Guwahati Development Authority do in other area, my lord. So this is prohibited, my lord.
Sorry to say, we are interested, but no such meetings are there.
Dear my lord, this is dear my lord. She may come to then, my lord.
The green belt and all, and this is, no meetings are there.
My lord, dear my lord, lord, she may come to then paragraph, if I could remember correctly, my lord. 45 and exactly, no? And exactly. Sixteen, my lord.
Yes.
Paragraph 16, page 19, my lord. The petitioner, they, especially here is a statement, my lord. The ground has been taken, my lord, against those statements, my lord. The petitioner beg to state that Ministry of Environment, Forest, Climate Change published a draft notification in the Gazette of India, being so and so, to notify an area spread over 109.99 square kilometer as to the extent of varying from 170 meter to 8.1 kilometer around the boundary of the Amsong Sanctuary situated within the Kamrup district as eco-sensitive zone to preserve the eco-diversity of the region. My lord.
They specifically replied this,
No, my lord.
we are bound, it is there. They have replied this.
My lord.
that they are bound to maintain whatever the boundaries and all.
No, my saying is that, my lord, when, my lord, there is a eco-sensitive zone, when is a tribal bell and block, my lord, this Act 2017 Act cannot be extended because of they have to develop those areas. As per section 33, my lord, 17, there is a provision that will take care of the, my lord, scheduled tribe or the scheduled tribe areas, my lord. Let's say we come to the section 17, my lord. But if you go to the section 33, my lord, that is completely against the provision, my lord. They contradict each other, my lord. Let's see, may come to that act, my lord. Yeah. My lord, let's see, may come to page 70, my lord. I have annexed the act, my lord.
Yeah.
Page 70.
Yeah.
Paragraph, my lord, section 17, my lord.
Yes.
So may I read, my lord? The preparation of functional plan and sub-regional plan, master plan. After the regional plan has come into operation, the authority may prepare as many functional plan as may be necessary for the proper guidance of the other authorities and local bodies concerned with their consultation. Each authorities and local bodies are empowered to prepare a functional plan, sub-regional plan, master plan, or sub-region. Each sub-regional plan, master plan shall be written statement and shall be accompanied by such map, diagram, illustration, and descriptive matter as the authorities and local bodies concerned may deem appropriate for the purpose of explaining or illustrating the proposal contained in sub-regional plan, and every such map, document, illustration, and descriptive matter shall be deemed to be a part of sub-regional plan, public master plan. The a sub-regional plan may indicate the following elements to elaborate the regional plan to the sub-regional level, namely the reservations of area for the specific land use, which are of the regional and sub-regional importance, including green belt, urban areas, and recreational areas, tribal belt block area, and autonomous council areas within the state capital region shall be developed, keeping in view the existing law with the preservation. So if we say about the existing law, my lord, did Assam Land and Revenue, my lord, chapter 10 will come, my lord. This is the existing law.
Yes.
And culture of the tribal, culture of the tribal block and the prior consent of these authorities mandatory for finalizing the regional plan covering the respective areas. The future urban and major, these are not relevant. Lord, we may come to section 33, my lord. 74 page.
Yes.
Power of authority to levy betterment tax, my lord. That is, my lord, we are troubling, my lord, in this provision, my
We
lord.
have challenged that provision 33. Validity of this provision is under challenge.
My lord, entire act is not applicable. I am challenging, my lord. It cannot be applicable to those area, my lord. Not specific, but I am just indicating the 33, my lord.
This is not
What is the hurdle for the people of the, my lord?
But this is not your favor.
May I read, my lord? 33(1). Where the opinion of the authority as a consequence of any development project or scheme have been executed by the authority in any areas, the value of any land in that areas has increased. Suppose, my lord, the GMDA or, my lord, the capitalism extended, my lord. They have developed the road or side by side something, my lord. The area become developed, my lord. The value of the land increase, my lord. So, my lord, has areas increases or will increase, the authority shall be entitled to levy upon owner of the land or any person having an interest therein the betterment charge in respect of the increase in value of the land resulting from the execution of the developed project or scheme. Suppose there is a multi-story or some market is coming, maybe, my lord. The nearby land is a cultivator. So it becomes developed because of, my lord, development. And he had to pay betterment tax. From agriculture, even he's hard to survive, my lord. Where from he will give the betterment tax, my lord?
So you have not challenged the validity of this act.
My lord, let's come to the prayer, my lord. My lord, prayer number 1, my lord. Charges shall not be issued directing the respondent to set aside quasi the extension of the jurisdiction of the Guwahati Municipal Development Authority and Guwahati Municipal Corporation to the tribal areas and block Kamrup areas and in certain district by enacting the State Capital Region Development Authority Act 2017 by impugn notification so as illegal, null and void, and being the contravention of the object and provision of the chapter 10 of the Assam Land Revenue Regulation Act 1886.
So now, first of all, in these regulations, 1886, is there any bar from acquiring the land of the scheduled tribes? Is there any complete bar?
Well, bar is there, my lord, except that their development, my lord. Except that their development
Which is
for
that-
other purpose is barred, my lord.
which is that?
My lord. Let's say we come to the my lord, the Assam Land and Revenue 160. 60. কি বলেছে তুমি Assam Land and Revenue? My lord, lordship got it, may I read, my lord? Even I have give the features in that my petition also. If on only 68 if on the day. Assam Renewable Revenue Section 160 legislation. You have no knowledge. Protection and backward classes. Where it, my lord, 160, my lord.
Yeah.
Protection of certain classes, notwithstanding anything herein contained, this state government may adopt such measure as it deem fit for the protection of those classes who. Well, hold on.
Yes.
My lord. 160, my lord, protection of certain classes. One, notwithstanding anything herein above contained, the state government may adopt such measure as is deemed fit for protection of those classes who, on account of their primitive condition and lack of education or material advantage, are incapable of looking after their welfare, insofar as such welfare depends upon their having sufficient land for their maintenance. The state government may, by notification in the official gazette, specify the classes of people whom it considered entitled to protection by such measure as aforesaid. So, my lord, accordingly, I have my lord, bad categorical statement in paragraph my lord, 8, my lord, in page 12, my lord. These are the classes, my lord.
Yeah.
Plain tribes, hills tribe, tea garden, Santhal, scheduled caste, Nepali, cultivator grazer, they have been later on withdrawn, my lord. Again, recently they have been, my lord, included. These are the protected classes. It's not only the scheduled tribe, my lord.
Okay.
So name is the Balan block, my lord. So these are the classes to be protected. So, my lord, let's see, may come to then, my lord, section 162, my lord. 61 or 64. 63. The constitution of compact areas, my lord. 161. The protection measure may include the constitution of compact areas in regions predominantly people by classes of people notified under the provision of the subsection to the sections 160 into bale and block. So there is a my lord 47 bale and block in my lord entire state of Assam. 19 is a my lord tribal development belt, my lord. These are my lord blocks, my lord. The boundaries of the area so concerned shall be as far as possible coincide with the Mosa boundaries or the otherwise easily distinguishable. So Mosa is the basically block, my lord. The entire 2-3 Mosa it become a my lord belt, my lord. So extension of chapter 10 to such areas, my lord. The state government may by notification in the official gazette direct the provision of this chapter shall apply to such areas or any of areas constituted into black and block under the section provision of section 161. On such application, the disposal of land by lease of ordinary cultivation, the nature of extent to the right of conveyed as by annual or periodic lease, the termination of forfeiture of any rights, the ejectment of person in occupation who have no valid right in the land, the management or letting out the farm of land in certain circumstances by deputy commissioner and other allied or concerned matter shall so far as possible be government by the provision this chapter and the rules made thereunder. So this is extended, madam. Chapter 10 is up to the block and Boria area, madam. 2. Notwithstanding anything in the contrary in any law, uses, contract or agreement, no person shall acquire or possess, my lord. So this is my lord. Notwithstanding anything to the country in any law, uses, contract or agreement, no person shall acquire or possess by transfer, exchange, lease, agreement, settlement, any land in areas considered into the barren blocks provision of contravention of the provision of the subsection 1, provided nothing contained in this chapter or in rule made thereunder shall affect any transfer by way of mortgage in favor of the National Bank cooperative societies, so and so, my lord, and such other financial institution as may be approved by the state government. From the above, from and after the commencement of the Assam Land and Revenue Regulation 1964, Amendment Regulation, no document evidencing any transaction for acquisition or possession of any land by of transfer, exchange, lease, agreement, settlement shall be registered under the Indian Registration Act 1908. If it appears to be the registering authority, then the transaction has been effected in contravention of provision of the subsection 2, my lord. 4. The state government may, in the like manner, direct the provision of the chapter shall cease to apply to an areas of provisions of any areas which they have been applied under. So this is the power entrusted to the state government. They can, my lord, denotify it. That means, my lord. So in case of this, my lord, the Dimuria tribal block, my lord, under Sonapur, they has not been notified, my lord. Without notification, my lord, they have extended. We are not on that, my lord. Without notification, they have extended. So because of this, people are protected by the provision of this. If it is extended, that, my lord, protection of the provision will be, my lord, useless, my lord. They will be not protected because of the development. They have to, because the Guwahati, you see, my lord, up to 2019, my lord, the population pattern of Guwahati, now nowhere, my lord, you will see the local people, tribal people or other scheduled caste and other backward classes people who are under protected, my lord. Now this is a commercial place, my lord. Tomorrow, Sonapur area will be a commercial place, but nowhere, my lord. The Amsong Reserve Forest, my lord, the Amsong, my lord, Wildlife Sanctuary, and the block will be required to be denotified, my lord. If this way slowly, my lord, gradually allow this, my lord, this way, my lord. Tomorrow, some will construct a building. Day after tomorrow, my lord, they will sell the land. Day after, my lord, somebody will claim there is no protected class in this area. This is required to be notified, my lord. This is the process, my lord. So it is clearly violation of chapter 10, my lord, of the, my lord, regulation act, my lord, regulation, my lord. And thereafter, my lord, lordship may come to section, my lord, 64, my lord. These are the some rights given to the my lord, settlement holder and landholder. Then 64, my lord, how to eject, what way eject, my lord. There's a provision, my lord. Even that is not, but earlier, my lord, in a PL, this court has directed, my lord, to evict those people from that has been not till now, my lord, they have applied, my lord. No eviction has been made so far, my lord. No scrutiny has been made, my lord. My lord, the land, acquired for the, my lord, this Assam rifle, my lord. If we see the people's name, my lord, they are not the resident of that locality, my lord. They are the resident of Guwahati, my lord. They are purchasing, my lord, done, they are, my lord, in violation of law. And being an interested person, they are getting the, my lord, amounts, good amount. Why they will object, my lord? Where they have no right, they have got a good amount, my lord.
This is not your ground. You have not taken this ground in the petition.
My lord, that ground I have not taken, my admittedly, because of, my lord,
Then sir, we are not supposed to take into consideration that.
because, my lord, these people are very hard to get. Those people's, my lord, the record documents and their addresses, my lord. You see the, my lordship, that or land, the name of the person who was holding those land, my lord. These are not easily, my lord, very hard to get those information, my lord. What not land, right? See the names of those people, my lord. '83, my lord. I am not, my lord, asking any direction against them, my lord, but
Then, so you have not.
no, my lord, if it is illegally, my lord, applied section 40, my lord, court has to interfere so that they cannot do in future also. Maybe this has been, my lord.
That is the question will consider it. But so far as regarding the persons who is given the compensation, they are entitled for it or not. That
I'm not
is the
disputing. I'm, my lord, for my arguments, just I'm advancing that how it's happening, my lord. What is going on? That way I'm just analyzing, my lord. I'm not making any statement against them, my lord.
Then you can find the arguments up to the pleading.
My lord, suppose that, my lord, section 33, my lord, again, my lord, let me come to, my lord. There are two, section 32, my lord, I stop there, my lord. Page 74, my lord. Again, I am reading them, I put two, my lord, 32. Such betterment, lordship God.
Yeah.
Such betterments shall be an amount not exceeding one half of the amount by which the value of the land on the completion of the execution of the development project. So one half. That means 50% he has to pay. According to the measurement, assessment, calculation, what kind of development they have done. So one half, my lord. If it is the, my lord, it become a revenue of 50,000, my lord. If they are required to pay, they have to sold it out the land, my lord.
Yes.
If that is area is developed nearby, my lord, if the value of the land increases, he may not get any benefit. Because of development of nearby site, he is the sufferer. He have to pay the tax, my lord, betterment tax, not the land revenue. Land revenue would be hardly, my lord, 100 rupees, 200 rupees, 500 rupees. That is can be accommodated, my lord. So there is no measurement of the betterment tax, my lord. It is mathematical, my lord. How much, my lord, development, that much, my lord, betterment tax. How it possible for the, my lord, scheduled type people or the other protected class in the, my lord, the bell and block area, my lord?
Yes.
If the land where the buildings exceed the value of the land immediately before such execution estimate in like manner, provided that in levying betterment charges on any land and land, the authority shall have regard to the extent and nature of benefit accruing to the land for the development project or scheme and such other factory as may be laid down by the made in the. Suppose there is a commercial hub, there is a, suppose, my lord, the cement factory, They are individually, they are getting benefit. Why the neighbor has to bear the cost of the betterment tax? What is the logic? Because of this, this provision is there, in the Delhi Development Authority Act 1957, Because in Delhi, there is no protected class, there is no protected area, Possibly because of that, they are not thinking about the other provision of the state of Assam applicable to the protected classes, They have brought into this, I can show, I have not bring that the Delhi, I have set up in online, This provision is there in the Delhi Development Authority Act, or the Greater Delhi, So there is no protected class. There is no schedule type, no schedule caste, There is a capital city. Anybody can go, anybody reside here, In case of Assam and Delhi, protected area, there is some reservation, There is some restriction, So that this cannot be applicable to those areas, Otherwise, I am not opposing the development. But development should not be a, the people who are supposed to be enlightened, they should face the poverty, They have to be evicted from the land, They have to relocate their, present place of residence, That should not be the purpose of the capital region. We are most welcome, They have developed the capital region, one of the best city in the world, We have no objection. But not in cost of these people, marginalized people,
Without acquiring, you are expecting that the best city of the world, without acquiring the land for urbanization, can be done. In the year.
Keeping those areas, in protected area, that can be done, No, Bara, I am not saying, Those areas, the Sonapur, Dimuria block, under Sonapur Revenue Circle, this is required to be protected and the Amsong Wildlife Sanctuary, that is a notification of March of 2017, and this notification has come in the 2010, October 2017, So this is a subsequent notification. This is a central government notification. We cannot bypass the provision and the wildlife, the Amsong Wildlife Sanctuary Act, But Amsong Wildlife Sanctuary, I have not annexed, but I have made that statement, This is the copy, This is it.
What is it?
That, the Amsong, Wildlife Sanctuary,
Yes.
This has been notified in the Gazette of India, on 7 June 2017, but the notification, have been, on 7 May 2017,
Yes.
This is, let's may come to, this is a, the, third page, and whereas, I'm reading from,
Yes.
It is necessary to conserve and protect the area, the extent and boundaries of which are specified in paragraph 1 of this notification around the protected area of Amsong Wildlife Sanctuary as eco-sensitive zone, where some construction is prohibited, From ecological and environmental point of view, and prohibited industries or class of industries and their operation and possesses in said eco-sensitive zone. Now, therefore, in exercise of the power conferred by subsection 1 and clause 514 of subsection 2 and subsection 3 of section 3 of the Environment Protection Act 1986, read with rules, sub-rule 3 of Rule 5 Environment Protection Rule 1986, the central government hereby notified an area of Amsong Wildlife Sanctuary in the state of Assam as Amsong Wildlife Sanctuary eco-sensitive zone. So this is the boundary, the extent and boundary of the eco-sensitive zone. This covers the all those areas, Then, the zonal master plan for the eco-sensitive zone, 2, The state government shall, for the purpose of eco-sensitive zone, prepare a zonal master plan within the period of 2 years from the date of publication of final notification in the official gazette, in consultation with the local people and adhering to the stipulation given in this notification for approval of competent authority in the government. The zonal master plan for the eco-sensitive zone shall be prepared by the state government in such manner as is specified in this notification and also in consonance with the relevant central and state laws and the guideline issued by the central government, if any. The Junel Master Plan shall prepare in consultation with the following state department for the integration the ecological environmental consideration into the said plan. The environment, forest and wildlife, agriculture, revenue, urban development, tourism, rural development, irrigation, flood control, municipal, Panchayat Raj, public work department. So the Junel Master Plan shall not impose any restriction on the approved existing land use and infrastructure activities unless so specified in the notification, and Junel Master Plan shall be factored in improvement of all the infrastructure and activities to be more specifically and eco-friendly. The Junel Master Plan shall provide for restoration of denuded areas. So this is most important, my lord, because he'll be, my lord, if the extended, my lord, all will be barren, my lord. Conservation of existing water bodies, management of catchment area, water source management, groundwater management, soil and moisture conservation, needs of local community, needs of local community, that is so important. And such other aspect of the ecology and environment that need attention. My lord, let's see, may come to the 3, my lord. I'm leaving this rest of the 3, my lord. Next page.
Yes.
Measure to be taken by the state government. The state government shall take the following measures in giving effect to the following provisions of the notification, namely land use, how to use, my lord. A, forest, horticulture area, agriculture area, park and open space earmarked for recreational purpose and eco-sensitive zone shall not be used to convert into area of major commercial or major residential complex and industrial activities. So this will extend, my lord. If this region act is 17 is extended to the, this will automatically going to happen, my lord. Provided that the conservation of agriculture and other land for the purpose other than specific within the eco-sensitive zone may be permitted on the recommendation of the monitoring committee and with the prior approval of the competent authority under the relevant state law and the other rules and the regulation of central public state government as applicable, and fight provision of this notification to meet the residential need of the local resident as such, widening and strengthening of the existing road and construction of the new roads. Only these are permissible, my lord, in case of, my lord, this eco-sensitive zone, my lord. Construction and renovation of the infrastructure and civic amenities. Small-scale industries and not causing pollution. Cottage industries, including village industries, convenience store and local amenities, supporting eco-tourism, including the homestay. Promoted activities and given uses in para 4. Provided further that no use of tribal land shall be permitted to be commercial for commercial and industrial development activities without the prior approval of the competent authority under the relevant state law and under rule and the regulation of the state government without compliance of the provision of Article 244 of the Constitution or the law for the time being in force, including the scheduled tribe and other traditional forest dweller recognition forest size act 2007, my lord. These are the protected provision of law, my lord. So this will be a bypass, my lord. The 2007, my lord, extension of the, my lord, the Assam State Capital Region, my lord, extension, my lord, are to this area. These, my lord, purpose of those protected laws will be diluted, my lord. They will be not protected by other laws if that is extended, my lord. Provided also that any error appearing in the land record within the ecosystem shall be corrected by the state government. Suppose if some land record is not that, my lord, who are protected class, is this required to be corrected even as per, my lord, land revenue regulation, my lord. If non-protected class is purchasing a land, my lord, if it is bring to the notice of the revenue authority, they should revert, my lord, the land to the person, my lord. This is the law, existing law, my lord. They have not done, my lord. I am not on that, my lord. How gradually, my lord, the protected class have been, my lord, area have been become slowly commercialization, my lord. They will be not protected, my lord. Provided also that the above correction of error shall not include change of the land use in case of except such provided under subparagraph. So cannot the use of the land cannot be altered, my lord. Effort shall be made to reforest the unused or unproductive agricultural areas with afforestation and habitual restoration of that.
Yes,
My lord, that is important, my lord, in respect to my lord, that area, my lord, Assam Rifle area, my lord. Efforts shall be made to reforest the unused or unproductive agricultural area with afforestation and habitat restoration activities. Those land, my lord, 144 bigha. As per this, within the eco-sensitive zone, it is within, my lord, nearby, my lord, Amsong Wildlife Sanctuary, and it is within the, my lord, protected class area, my lord, the Dimuria Tribal Development Block, my lord. So it is to be, my lord, as per this, they have to do something different, my lord, not the construct, my lord. These are prohibited, my lord. They are about bypassing those, my lord. My lord, then water bodies, tourism, ecotourism, that, my lord, the tourism, ecotourism, then, my lord, D1, Roman 1, my lord, D1, this is very important. No new construction of hotel. Resorts shall be allowed within 1 kilometer of the boundary of the wildlife sanctuary or up to the extent of eco-sensitive zone.
so hotel.
My lord. The national highway, my lord, from the Guwahati
they're
towards
constructing
Nagaon, my
it.
lord.
So they are constructing a hotel here.
My lord, nearby, my lord, this area, my lord, within 1 kilometer, my lord, they cannot, my lord. So it is just 500 meters is Amsong Wildlife Sanctuary, my lord, from the road. They have done so many things, my lord. I am not bringing those, my lord, making any allegation.
If you are not bringing those, sir, please confine your answer to the PI.
Well, this is my
Yes,
confine.
sir.
I am confining, my lord, because of the I am bringing.
Sir, you are objecting to this acquisition of 144 because of the land for the purpose of this Assam Rifles. Up to that.
What is the urgency, my lord? Urgency should be, my lord. I have to read that on a three purpose they have acquired, my lord. For army, my lord, national calamities, and my lord, one word I forgot, my lord, they on the three purposes. So this is not an urgency. If this is a border area, that is different. In a capital near making one camp for, my lord, their key location. I think the word is key location. So that
you
they can
if they-
locate a
and
place.
if they can, they could have acquired near
Somewhere they could have,
near the border, not in Guwahati.
not in, urgency is required in the border. If defense purpose it is required, we have no objection.
And,
But in a
border is too far
capital
from-
city, my lord, where
Border
it is,
is too far from Guwahati. There is no urgency of acquiring the land for the Assam Rifles in the Guwahati town.
they can, my lord, anywhere, but not in the barren block area.
Right.
That, my lord, urgency has been locked because there be environment assessment report, my lord. When they use the urgency clause, that is not required to done, my lord, as per section 17, my lord. So after that, they are required to notify, my lord, give the notification. Thereafter, the objection will be invited from the landowner, my lord. There will, my lord, according to assessment report and the objection of the owner, the government will decide, my lord, whether the rain is to be required or, my lord. That is not applied, my lord. This is urgency clause, my lord, within a 1 month, he occupy, give them compensation, go out. They have nothing to say, my lord.
Yes.
So that is not applicable in respect of this, my lord.
Yes.
Let's say, may I come to 140 mile, 40 mile then? Yeah, not. 40 my lord. Special power in case of urgency to acquire land in certain cases, my lord. No. May I read, my lord? Special power in case of urgency to acquire land in certain cases. In case of urgency, whenever appropriate government so directs, the collector, though no such award has been made, may, on the expiration of 30 days from the publication of the notice mentioned in section 21, take possession of any land needed for the purposes, and such land shall be thereupon vested absolutely in the government free from all income branches. The power of the appropriate government under subsection 1 shall be restricted to the minimum area required for defense of India, national security, for any emergency arising out of national calamity or any other emergency with the approval of the parliament. So if this is any other emergency, there is no approval from the parliament. Is it any other emergency immediately required that something will happen, my lord? If that land is not required or these people are not put there, my lord, to protect the people. This is a best camp. Whoever in the northern region, my lord, Assam level, they will came there, my lord, as a rest camp. This is not urgency clause, my lord. Cannot apply, my lord. Otherwise, they have to, my lord, according to my lord law, they have to, my lord, made a notification, my lord, under section 11, my lord, preliminary notification. Then objection will be invited, my lord. Then payment will be made, my lord. Then the who are become, my lord, homeless, my lord. They have to relocate somewhere, my lord. These are, I'm not bringing to the argument, my lord. Just I, my lord, keeping in mind the to the urgency, my lord. I am just placing before lordship, my lord. So what is the urgency, my lord? Secondly, my lord, may I come to the next, my lord? Provided the collector shall not take possession of any building, this is not required. 3, before taking any possession of the land under the subsection 1, subsection 2, the collector should tender a payment with of 80% of the compensation for the such land as estimated by him to the person entitled thereto. In case of any land which is opinion of the appropriate government, the provision of subsection 1, subsection 2 or subsection 3 are applicable. The appropriate government may direct that any and all of the provisions chapter 2 and 4 shall not apply, or it does not direct of the declaration of may be made in the section 19. So these two chapter 2 and 4 is they have bypassed because of the urgency clause. The chapter 2 and 4 is regarding preliminary notification, objection, my lord. Then environment impact assessment report, my lord. These has been what bypassed because of this applicable of section 40, my lord. So what is the urgency, my lord? Then lordship may come to the section 41, my lord. This is protection for the scheduled caste and scheduled type people, my lord. Section 41, my lord. Married, my lord. As far as possible, no acquisition of land shall be made in scheduled area. It is not saying that from the scheduled person, scheduled type person or scheduled caste person or other protected class from area, my lord. Not supposed to be mean that some this protected person, my lord. This is from area. Where such acquisition does not take place, it shall be done only a demonstrable last resort. So there is no option at all, my lord, to set up those camp, my lord. Then they can, that has to show, my lord. It is not that the land is not available, my lord, in Guwahati, but nearby area, my lord, the nearby district, my lord. Why they have chosen those protected area, my lord? Where such land does not take place, it shall done only as a demonstrable last resort. In case of acquisition or alienation of land in scheduled type area, the prior concern of the concerned Gaon Sabha. So the Guwahati municipal, there is no what, my lord, as is not extended. So where they have taken, my lord, the permission from the Gaon Sabha, my lord. Or the Panchayat or the Autonomous District Council, there is a, my lord, Amri Development Council, who has to some kind of, my lord, power in that area, my lord. They have not been consulted. Who are the petitioner before lordship, my lord? How they are, that's why they are, my lord. They have the locus standi, my lord, filing this petition, my lord. At the appropriate level, scheduled area under the fifth schedule. Fifth schedule is not applicable in the state of Assam, northeastern region, my lord. It is the rest of the country. And sixth schedule in fifth schedule area of the constitution, as case may be, shall be obtained in all cases of land acquisition in such area. Even if the, my lord, 40 section is applicable, even that in the tribal areas, my lord, this is required, my lord. This procedure is required to be followed, my lord. Even then, if you apply the urgency clause, it is non-protected area, my lord. If it is a protected area, even that is, they have to do this exercise, my lord. Including acquisition of case of urgency, including in case of urgency, before issuance of such notification under this act or any other central or state act or for the time being in force, provided that the consent of the Panchayat or the Autonomous District Council shall be obtained. So here is not Autonomous District Council, Panchayat is there, Gram Sabha is there. 4. In case of projected involving land acquisition on behalf of the requiring body which involvement voluntary displacement of the scheduled tribe or the scheduled tribe families, a development plan shall be prepared. Though this is not important, I'm coming to 6 minor subsection. In case land being acquired from the member of the scheduled caste and scheduled tribe, the less than 1/3 of the compensation. So here also minor, only few people are there minor, but rest of the minor not protected class minor. So this is the provision. May I come to 9 minor? Subsection 9 minor. Any alienation of tribal land or lands belong to the members of the scheduled caste in the regard. This is regarding their land minor. But in case of area minor, this procedure is required to be followed. In case of land from the specific person minor, these are required minor. How to pay, what to do, where he is to be relocated minor. These are different things. But in case of minor area, if it is not belong to anybody also, it is area of the minor, that protected area minor. That other procedure is required to be followed, minor. Otherwise also minor, the 44 of the minor Constitution of India, that some minor has to do for the name minor. May I read the minor section 44, the article 44 of the Constitution of India, minor. The welfare of the minority protected class and scheduled type minor.
You are the office bearers.
Minor.
What position you are?
President and secretary of the American race are the minor, some three organizations is there
Secretary of
included.
the-
Minor.
Who is the secretary?
Secretary minor. Minor Horan Fangsu is the president, petition number 2, and 3 is the secretary minor. The 1 is the minor society minor.
When he was elected as the president.
My lord, that I have not stated, my lord. That time I was the president, my lord. My lord, paragraph 5, my lord, of my writ petition, that page 9.
You are the development society.
My lord, the America Development Society, my lord. We are look after the areas, my lord, to some causes.
Any representation on your part?
My lord, lordship may come, lots of representation, my lord. Lordship may come to my lord, page 85, my lord.
Is national concept. America, the national concept.
My lord. My lord,
All representations are by national concept. Development society has never raised it at any point.
my lord, actually, I have not made calculation. They are the same, my lord, person. They are the persons, my lord. They are the present secretary of the Development Council also.
When this development council has ever raised any objection regarding this?
My lord, I'm coming, my lord, several things. The secretary, American National Council. I think, my lord, this is a registered organization. That's why they have.
Is that registered organization?
Madam. Lordship is correct, my lord.
Para number 9, para number 20 of the writ petition, page 21.
My lord, the petitioner beg to state that American Army Development Council file objection against the notice regarding publication of the draft delimitation of the new Guwahati metropolitan region and revision of the master plan of Greater Guwahati covering Dimuria Tribal Development Block, Guwahati Tribal Block, and Rani Tribal Development Block. The Amrikarbi area of the to the Honorable Chief Minister of Assam, Government of Assam, Dispur, Guwahati, through the circle officer. Further, similar copies of the joint representation also submitted to the Honorable WPT Minister, WPT and BC, and the Chief Executive Officer, Guwahati Metropolitan
You are
Development.
not the national council,
My lord,
you are the development.
Development Council, my
Whether
lord.
Development society has raised any objection.
My lord, that is my lord, rightly, my lord, also raise the issue, my lord,
Huh?
because they are the same person actually.
Not the same,
My lord, my lord, my lord.
same person.
Anyway, my lord, otherwise also may not be the my lord Amrikarbi Development Council, my lord.
Sir,
Even then, my lord,
Sir, for the purpose of entertaining a PIA, bona fides of the petitioners are required to be seen.
even
sir.
they have raised also.
Sir,
As a public, I can take records of those documents, my lord.
not under
Because
the
somebody
name
has
of
not
a
done.
society.
In the society, some organization done.
Sir, in
I have
fact-
taken the records of that
In fact,
claim.
in fact, you are trying to jeopardize the rights of the people who have already got the compensation of the land. Suppose tomorrow if we pass any order in this writ petition that de-acquire this land and give to those persons who have already paid the compensation, what will happen to those persons?
My lord, lordship, if they have already established, it cannot be done. But it cannot be a precedent, my lord. That is my humble submission in the initial my lord submission. It cannot be a precedent, lords. Make an observation. Then in future, do not violate those laws in respect of those areas, my lord.
You are a registered society.
My lord, possibly racist.
Sir, what possibly and not possible?
My lord, my lord, my lord. Right, sir. What's it?
You have not raised any objection at any point of time regarding this. And one five only,
My lord, paragraph 5, my lord, registered society.
paragraph,
5, my lord.
paragraph 5, there is a registration
My
certificate.
lord, that I have not annexed, my lord.
Then it is a, you have not submitted, it's a registered society, but no such document is there.
My lord, I have possibly because they have.
Possibly.
My lord, not with my record. I'll bring my lord, if required, my lord. I'll make an additional affidavit, my lord, bring to the my lord the registration, the certificate of the registration, my lord.
Going to now consider.
এটা তো শাসন পুষ্পালা করে registration certificate জন্য। এখন প্রেজার হবে। উল্টাই লয় ফেলে উল্টাই লইটা। কালকে তো না, এটা কোন ফাইলটা গুছাইল আসলে। উল্টা না করবে। In case of public interest, my lord, may not be I have filed that. If somebody has filed, my lord, public spirited person, I can take, my lord, those matter, my lord, the issues. There is no bar. But in case of my registration, my lord, If Lordship may permit me, I'll, my lord, produce the registration certificate. If I have made a categorical statement as a registered society, my lord, I'll produce my lord. Okay. In case of public interest, my lord, that cannot be, where larger interest is more, my lord. If I have filed a PL in a vested interest, that is different thing, my lord.
Sir, your secretary, petitioner number 2 and 3 are the president
And secretary,
of who, of which this
the American
Army Karpi,
Development Society, my lord.
you're the president of Army Karpi, this development society or national council?
Not National Council, my lord. National Council has filed up, my lord, representation. They have filed.
You are the president and secretary of
The Army Karbi Development Society, my lord, the
Development
petitioner, my lord.
Society.
Development Society, the registered organization, my lord.
And you are not the president and secretary of the Army Karpi National Council.
We are not secretary, but we are also involved there, my lord.
You are also involved there.
My lord.
Then how you have made this statement in this para number 5? The petitioner number 1 is Karbi Development Society, which is a registered society working to protect and update the Amri Karbi community residing in the state of Assam, excluding the scheduled district of the state. The petitioner number 2 and 3 are the president and secretary of the above said society, respectively, and they belong to the scheduled tribe, Amri Karbi tribe community. Fine.
Fine, my lord.
Now come to next page. Para number 2. The petitioner number 2 and 3 are also president and secretary of the Army Karbi National Council.
My lord,
So
that-
as per your statement,
My lord.
petitioner number 2 and 3 are president, secretary.
exactly,
of
my lord.
society
When the
and
representation,
council also.
my lord, when the representation was filed, they are different person. Subsequently, we become when, my lord, the case was filed, my lord.
When, sir, when you become?
My lord, because the petition was filed in, my lord, 2020,
Yeah.
the representation was prior to that, my lord. That time, my lord,
No, not prior to that, sir.
my lord, that time was those person whose name has appeared, my lord.
Sir,
That's why I said, my lord, we are in the same, that organization or this organization also, my lord.
Sir, please try to listen. Representations are also of the year 2020, 2022,
My lord, maybe,
2015.
maybe before filing few days back, my lord, they have sent the society, the
Okay.
committee sends
So
the name,
you
my
are
lord.
supposed to
That is
disclose that when you were appointed, when you were elected.
That is missing, my
You
lord.
are
That I admit, but I can produce, my lord. That I can
We
buy
are
an
not
additional
going to
affidavit.
give time for that.
My lord, when the public interest is involved, my lord,
2015, 18, 19 and 20, all representations are there. You are neither president nor secretary. Some other person is president of the National Council and you are claiming I am the president of the National Council. It's great.
my lord, that technicality, my lord, cannot be a, my lord, wipe away the public interest, my lord. That
Last
technical,
representation is of 6th of November 2020.
maybe, my lord, they, maybe next, prior to that, they have sent, my lord.
Maybe,
That I'll explain, my lord.
maybe for that reason.
Because I have filed a petition on 1/12/2020, my lord.
So 6
1st December.
2020, in between 6/12/2020, he was elected as a president and secretary of the this council. You are a busybody and nothing else.
কিরকম আমার নাম সাথে দিয়েছে পিঠের নামটা এরকম সব কমেন্ট My lord, lordship is my lord considering
We
the
are not at all satisfied with their bona fides and we are going to impose a heavy cost on. them.
my lord, it is a public
No,
interest,
this
my lord.
is- This is not public interest at all.
What,
This is.
what kind of
this is
interest, my lord?
private interest and
What
nothing
kind of
else.
interest I going to get, my lord? If I file a PL, what
We
kind of
don't-
interest?
We don't know. We don't know what interest we are going to get.
Because of the representation
benefit
filed
we
by
are
the
going to get.
some persons, I am taking because of that. It does not mean that I don't have public interest, my lord.
Sir, ultimately.
We have to see the, my lord, remote.
We have to satisfy ourselves with the bona fides of the petitioners. In the public interest petition, that's all.
My lord,
And we are not at all satisfied.
bona fide, I do admit, my lord, there is some mistake, my lord, in
Then mistake,
that-
then it's okay.
that
It's-
cannot be a, my lord, in a public, that is not a repetition for myself, my lord, violation of
That
rights.
we'll deal with. With that we will deal with.
Because this is the clear cut of violation of law, my lord. But because of locus standi, court, my lord,
First
has
of
to
all,
require to be interfere, my lord.
Mr. Concept, first of all, you have to satisfy regarding the bona fides, then only we'll proceed further and we are not at all satisfied. That's why
Then
we are-
court permit me, I will file an additional appeal
Not
bringing
at
those
all.
things,
We
my
are
lord.
not, it's
But
5
this is a
years.
public interest, my lord.
It's almost 5 years.
The code
Public
is-
interest, you
my-
can't
My lord, code
misuse
is,
this,
my lord,
misuse this forum.
who are
for
people,
whatever the
my lord,
reasons.
who do not have that much education, who are residing in a protected class, my lord.
Sir, don't.
In their case,
First
court
of all,
should have taken liberal view, my
show
lord.
your bona fides.
With the justice of court, my lord, I am not coming through to existing someone's
Sir,
right,
That will deal with it.
my lord.
That we will deal with.
Court has to, my lord, compensate for them, my lord.
Yes.
Those people, my lord.
Certainly, but court is not supposed to entertain
these
all
technicalities,
various
my lord,
petitions by the
on
persons who
technicalities-
have no interest in the matter.
But in a PIL, my lord, technicalities cannot be a ground.
It is certainly, it is a ground, it is the primary duty of the court first to satisfy.
Bona fide, my lord.
Yeah,
That I understand,
then
my
only
lord.
proceed further. This is what the. settled
Except
law
the
is.
president and secretary who has filed a representation, there is a bona fideness, there is, my lord.
Whatever it may be. We
It
are
is not that somebody has filed, raising an issue, I have filed a petition taking on the records of those issues, my lord.
Goes for-
Cannot be a, my lord.
Order is a.
Term is not in public interest, my lord.
Order is a. Public interest will take care of.
And if lordship permit me, I will give some suggestion, my citation other day, my lord, regarding.
Not at all. After 1.5 hour, arguing after on the very first instance, we have asked you regarding.
We have said
bona
later on,
fides.
we become the president secretary of that organization, my lord. When the representative filed by them, my lord, there's a statement lordship has pointed out to me, my lord.
You should have filed then and there when you have filed the petition. You should have checked it. It's not a matter of courts, I will give you the time and it's not.
In case of public interest, we are also taking the
Public
liberal,
interest, certainly public
liberal way,
interest.
my lord, because anybody can raise. Anybody can raise is
Sir,
a
even the court can. take
issue is,
so-
my lord.
Sir, in the public interest, even the court can take so much of cognizance also.
Not
But
to
if a
stop it
person,
also, suppose I am bringing to the notice of
but
the honorable
if a
court.
person.
Why court cannot? My lord, suppose my lord, I am bringing to the notice of the
Okay,
honorable court,
yes,
court can
yes.
also, my lord.
But if a person approaches the court, he is supposed to approach the court with clean hands and clear bona fides, not with any.
My lord, bona fide is, my lord, that much we are not
That
interpreted
will
in
deal
PIL,
with
my
it,
lord.
sir. Let us
In a repetition, my
leave
lord,
it to us.
that is different thing, my lord.
leave it to us, we'll deal with it. We'll deal.
I love judgment.
Item 3 and 4.
This is a matter where, my lord, the where the mediator was appointed, my lord, where the mediator was also appointed.
Last
Yes.
occasion.
Last occasion, my lord.
Had any objections under section 5?
Yes, my lord, I am coming. Section 4, your lordship may see, my lord, section 4. पैकेट में section 4.
Section 5A.
No, yes, that is why, my lord, I'm to section 4, because they have not, public notice has not been given, my lord, immediately.
Huh?
Public notice has not been given. That is the last date, my lord, to count it. I shall place the judgments also of Supreme Court, my lord, in this regard. Section 4(1). Because this section was amended, my lord, in 84. Whenever it appears to the appropriate government that land in the locality is needed or likely to be needed for any public purpose or for a company, a notification to the effect shall be published in the official gazette and in two daily newspapers containing in the locality, of which at least one shall be in the regional language, and the collector shall cause public notice of the substance of such notification to be given at the convenient places in the said locality. The last date of dates of such publication and giving such public notice being hereafter referred to as the date of publication of the notice. My lord, the Supreme Court also says, my lord, in this matter, in this regard, same way, my lord, just I refer to the judgment of the Supreme Court, my lord, 84/4 SCC 8. When 30 days will be come. Now that your loss will find, my lord, that section 5 says, my lord, 30 days, my lord, it will find.
Yes. What do you
Yeah,
want to say?
in this matter, my lord, at page 75, my lord, if you also see, they have page 75 of the appeal. They have published in the paper, but they have not published the locality, my lord.
Huh?
In the locality, they have not published it.
Which locality?
Page, yes, that is in section 4, my lord, it says. Circle officer, they have, my lord, published.
Seven. Yes, this is page 75.
Page 75.
It is.
My lord, the second paragraph. In an instant case, notice under section 4 was approved by the government by letter number so and so, was published in the Assam Gazette on 18/10/12, and the same was published in the two local dailies so and so on 27/11/2012. Again, the copy of the Gazette notification was sent to the circle officer, Dispute Revenue Circle by letter number so and so dated 10/9/13 for service in the locality.
Yes.
You don't know.
Appeal, my lord, sorry, I am 334, my lord. 334, I'm. Appeal number 334.
With reference to the.
334.
So, this page 75, yes.
My lord. So, my lord, before publication of the notice in the locality, we filed the objection.
Before publication of the locality, कहाँ पे आ गया?
Yes, that is, my lord, they sent only 11/9/13 for service of the notice in the locality. Yeah, very good. Suppose it death, two type of person, two type of suppose it as the idea, like. পরিষ্কার না করি, মানে মতটা Paragraph 3 and 4 of the judgment, my lord, your lordship.
Whether those objections,
Oh, yes. My lord, these are, my lord, at page 64,
84,
60, 64.
64.
One is page 64, other is, my lord, page 67. 64 and 67. Then, my lord, another,
This,
The PL code. Well, now, here what happened?
So the date of publication of the notice is 11/9/2020, 13.
13, my lord, that is, they have sent it.
2030.
13, they have sent it, and when it was published, my lord, we do not know.
Huh?
When it was published by the circle officer, because it was sent on 9/13, my lord.
So 11/9/13.
Maybe, my
is
lord,
the
but
date,
we
as
have,
per section 4,
yes, so,
as per
what,
section 4.
yes. So now, there is a large gap, my lord, from the date of gazette notification and so on. Now subsequently, my lord, they have published a notice in the daily newspaper, which is at page 72. If you'll also see the passage, my lord.
Hmm.
This is, my lord, notice, my lord, to see the who are the persons, my lord, is for general information or concerned that particular owners, title holders of land which is described below, that progress for acquisition of land for construction of the petroleum storage terminal at a village Betkushi under middle of Moda, and for the purpose of preparation of a correct and complete awardees list, field verification of plots and ownership rights will be carried on 8/10/2015 at 11 a.m. Now, this, if you also see, the notice was published in the paper on 9/10. Top. They fixed the date on 8/10. Well,
First of all, you have to satisfy that from the date of publication, within 1 month, you have filed the objection.
yes, my lord, before that, my lord, we have
Before
filed.
that is not to be taken into consideration. The objection under section 5 is to be filed within 1 month.
My lord, we came to know, my lord, that from paper, my lord, from the public, but so because after publication in the Gazette, my lord, we came to know and therefore we filed it. It is not that, my lord, before publication of any notification. After publication of the notification in the Gazette, subsequently we came to know, then we filed
So
this
the date of publication as per code is 11/9/2013.
13. That is the last, my lord. That's the last. My lord,
This is the only date of publication.
no, not only that.
It can
No,
be.
there are 3 dates, my lord. 3 dates of
Section,
publication.
come to section 4.
Yes. So for the purpose of my lord, section 5A, it is to be taken as the last, my lord.
Please come to section 4, sir.
Yes. Uh, Whenever it appears upon government that land is locality, shall be published in the official gazette and into daily newspaper circulating in the locality, of which or at least one shall be in the regional language. And the collector shall cause. This is the third one, my lord.
Sir, please read. But देखे तो सही, sir.
Yes.
पढ़े तो सही.
Yes. The collector shall cause the public notice of the substance of such notification to be given at convenient places in the state locality. The last date of such publication and giving of such public notice hereafter shall be referred to as the date of publication of the notice.
So the last day,
Yes.
the 3 modes are there.
Yes.
Notification, paper publication,
Yes.
and service.
Yes.
The date of publication would be deemed the last mode which is resorted to by the authorities concerned.
My lord, that is
Here in
correct.
this case, the
No, that-
last date is 11/9/2013.
My lord, it is not
Sir,
that, my lord.
what we understand.
Yes.
And therefore, you were supposed to file an objection under section 5A within 30 days from the last date of publication. The last date of publication, 11/9/2013, within 30 days, where is objection under section 5A?
My lord, that is not that, my lord, but that is only for the purpose of my right, my lord. That is, Supreme Court has said, my lord, that my right should not be affected. That is why this amendment has been done. Otherwise, earlier it was not so.
The Supreme Court para number 4 of the judgment, sir,
Yes, my lord,
which you have referred.
my lord. We may consider an argument that which is usually advanced any time gap between the publication of the official public notice for legality. Section 5 provides that any person interested in the land which has been notified under section 4(1) may object to the acquisition of the land or any land in the locality within 30 days after issue of the notification. It therefore suggested that publication notification by gazette is not immediately followed by public notice in the locality. It may lead to a denial of the person, my lord. That is what it says.
Yeah.
In denial of person interested in the opportunity to object to the acquisition. We think that this is too narrow an interpretation of section 5A.
Now, sir,
Notice of the interested
sir,
person.
come to page number 312.
312. Yes, 312, my lord.
Hello, sir. 312 of the judgment, hello, sir.
Yes,
And para number 4.
yes.
Now come to after 1, 2, 3, 4, 5. Fifteenth line, sir.
My lord, there is no reason.
No, it's a आगे वाली line पर.
Yes,
The period of 30 days may be reckoned
yes,
from either the date of publication in the Gazette
yes,
or the date of public notice
Yes.
of substance of the notification in the locality,
yes,
whichever is later.
yes. So, yes, sir. And
11/9/39, 11/9/2013
Now,
is the
your
later
lordship-
date.
Your lordship may further see, my lord, there is no reason to confine the period of 30 days prescribed by section 5A to one mode. It may not be one mode. The period of 30 days may be reckoned from either the date of publication of the gazette.
That observation is in relation to that because the objection of the authorities or the respondents was that if from the date of notification, no objection was filed within 30 days. Then they said, okay, no, the later date would be treated as a, and pursuant to this judgment, sir, this amendment was made in section 4.
Correct, my lord. That is why I am submitting, suppose after publication of the gazette, I filed, my lord, an objection. It does not mean that that is not an objection, my lord, at all. This is one aspect of matter, my lord. That is. Secondly, my lord, here what happened? The acquisition, my lord, after the acquisition, my lord, the property was not taken over by the, my lord, government. My lord, my property, what happened, my lord? There is a approach road from the national highway to my property. And they have divided my property, only a portion of the property on the two sides is taken along with the road. And my part of the property is kept as landlocked. That is why, my lord, the last time, my lord, has thought that there should be some settlement, because earlier also court passed various orders where MOU were prepared, my lord, that they agreed to give a road to my land, my lord. Because the part of the land has been acquired, part of the land has not been acquired, but the entire path has been acquired. So where from I shall enter into the land? That is why, my lord, if a loss will find that the mediation report, my lord, it has been clearly stated, my lord, what is there. They said either they should acquire the entire land or they should give.
Mediation report is of
No, my lord, that is
That's a value, sir.
not that, my lord. That is earlier orders are there, High Court. Earlier High Court orders are there. My lord, that if a lawsuit see, my lord. My lord, there are many judgments of the Supreme Court, my lord, that when the property, the land is not taken over by the government, my lord, no Rojanma has been prepared, that is, my lord, wrong. I shall place many things, my lord, many judgments to that effect also. My lord, here, my lord, the land has not been taken over by the acquisition authority. It has been forcibly taken by the company, for which we have to file as a my lord. I can place, my lord, a few judgments, my lord, in this regard, my lord. Because after all, my lord, my land has been kept landlocked, my lord, by taking my part, my lord.
They can very well approach the Supreme Court
My-
for that purpose, for the easementary right and everything.
No,
Right of way, can very well approach the civil court.
no question of civil court, my lord. I'm just, your lordship may hear, my lord. I said, please, my lord. Because they have to, my lord. Because initially they agreed, my lord, that they will give, allow me to go there, my lord, to my land. Subsequently, they refused, my lord, that no, authority has refused. Because this honorable court has passed order twice, that go and take the settlement, my lord. My lord, now I am placing, my lord, the judgments by which, my lord. Take it. The judgments, yeah. Well, I am giving a list of books, my lord, in this regard. If you want it, my lord, along with,
The list of books is,
no, list of books along with the judgments also, my lord.
and the relevant para, sir.
Yes, I am.
And please give
We have given
one
one.
judgment on one point.
Yes, my lord,
Don't multiply the number of the judgments
Yes.
on the same point.
my lord. If I said then you have to- my lord, your losses may just see, my lord, that
So this section 4 and 5A2, non-grant of hearing on objection acquisition vitiated. You have mentioned as many as 5, 6 authorities. The best authority which you are relying on this, please give us one authority. That would
five,
be enough for us.
on 5A. I'm giving.
4 and 5A, whatever
Yes.
it may be,
Well,
you have
what-
mentioned.
Four, my lord, I have given, and 5A, I'm,
73, 73, SCC 2013, 2017.
No.
On this
My lord,
same point,
on 5A, my lord, I'm giving.
sir, please refer one judgment.
One judgment, I'm referring.
Only one judgment.
Yes,
Sir,
I'm
why
referring.
the multiplicity of the judgment on the very same point?
Yes,
One judgment, the best judgment you rely on,
Idiom.
please give it to us.
yes, my lord, I'm giving. This is one of the judgment, my lord. I've given the para in the list, my lord.
Sir, which is the best judgment?
Yes,
Out of these 6
Yes.
judgments,
yes, list of it.
this 84, 4 SCC, 73, 1 SCC, 73, 3 SCC, 2013, 11
My
SCC,
lord, I'm not referring to others, my lord. 84, 4 only I have given to him.
84.
Four
You are
SCC.
relying on this 84.
Now, so far, this 5A is concerned, 1711 to 601, my lord.
These are the
2017,
two
11.
authorities, okay? Yes,
Yes. This one, my lord. And
now,
now, that, my lord, no Rojanama, section 16, my lord, I'm writing. No
okay,
Rojanama to show physical possession taken. On this, my lord, your losses may take up My lord, two paragraphs from my lord, 1613 and 1612, my lord. I'm just giving it.
2016-13 SCC.
And 2016-12 SCC, my lord. It's
12
very small, one paragraphs, my lord. I'm just.
Fine.
I'm giving. Okay, no?
That's all, sir.
That, my lord, and Anurag, my lord. Right to access to the highway from any point, my lord. On this, my lord, some judgments are there, my lord.
Right to.
That is Gujarat.
Okay. Gujarat,
Yeah.
Madras,
Yes.
and
Yes. This guy is political.
then
I'm giving one. Here, what happened? The facts your losses will see, my lord. Here, the photographs is given, my lord, here. The access.
all the judgments you are referring to are regarding the acquisition objections regarding the acquisition proceeding.
No, acquisition, acquisition, my lord, this was
So
17.
you are saying that acquisition was illegal, vitiated on account of
No,
these
there are
things.
two
illegal.
parts, my lord, two parts. First is section 5A hearing, that is, I have referred to 1711.
Fine.
Then second part, my lord, that the authority has to take possession of the land, thereafter hand over to my lord, the collector. Because at the time of taking our position, they will know the actual position, what is there. Because here, my lord, if your
Sir,
lawsuit,
we understand you are challenging the acquisition proceedings on the ground that these procedure has not been followed and there is a violation of these provisions. This is what you are saying.
my lord,
Just a minute. This is what you are saying.
my lord.
So basically you are aggrieved by the acquisition proceedings in respect of the plotting concern.
Yes.
Okay?
Yes.
Now what is your prayer in the writ petition?
No. My lord,
Sir, please come to.
there are two
Mr.
restrictions.
Saiwala, please first.
My lord, there are two restrictions, my lord. Another appeal is there.
Sir, another appeal will see.
My lord,
What is your prayer in the petition?
that is correct, my lord. That is, my lord,
This writ appeal number 333 of the 2022.
my lord, I'm sorry. My lord, first is, my lord, that right to fair compensation. And further, we please to quash the acquisition of land under the petition under the acquisition of, my lord.
Which petition you are referring?
Yes, this is the, my lord, petition.
Sir, there, one is 5956.
Yes. 6979.
6979.
Page number 48, yeah. 45 from it starts, my lord. 50.
Yes, that one. 6979. Now, please read your prayer.
My lord, may we please to admit this petition call for a record, it's a rule in the nature of mandamus upon the respondents to show as to why the provisions of right to fair compensation and transparency in land acquisition, rehabilitation, establishment act from 13 should not be invoked in acquiring the land of prisoner. And further, we please to quash the acquisition of land of the prisoner under the Land Acquisition Act 1894.
So your prayer was that apply the provisions of Act of 2013 instead of Act of 1894.
My lord.
This is what your prayer in the
Yes.
petition. Now come to the second, prayer of the second.
It is, in the previous report, it is paid the lordship please to call for record, it's a rule. The respondent is to buy mandamus should not be issued directing the respondent either to leave the right of way over the petitioner's plot of land covered by the so and so. Muja, the district of Assam, and provide alternative right of way to the petitioner's plot of land covered by so and so under Muja Belska so and so. My lord, this is the district of Assam. Or in the alternative, direct the respondent's authority to acquire the prisoner plot of land covered by Dag number so and so under Muja number so. Under so district of Assam. After payment of adequate compensation to the applicable law. My lord, this is.
You have not challenged the acquisition proceedings.
No, in the past case,
petition before the writ court.
no, in the past case, I have challenged my lord to that.
Not at all.
No,
You have said that acquisition is okay, but apply the provisions of 2013 instead of 1890.
no, now I am coming, my lord. Suppose, my lord, that I have not applied. My lord. Secondly, when the land is to be taken over, my lord, land will be taken over by the authority concerned. Then they will find actually what is there, my lord. Now here my right of way has been taken, acquired. Then my land has been, my lord, dissected. Some part of land has been made landlocked. My right under 300A has been violated, my lord. Because my land cannot be made landlocked, my lord. That is why other decisions are there, my lord. So here, my lord, that is what Supreme Court said, there must be, Rojanama must be prepared. And if Rojanama is not prepared,
Not challenge the acquisition proceeding as such in your petition. You, in first petition, you are asking for alternate ways, either to give alternate way or give some another way in the land which is acquired, or alternate land which is acquired, or acquire my land.
my land, my lord.
These
Yes,
are
that
the-
is also provided. That is also provided under Legislative Act.
These are the three.
Yes,
ways.
in the second case, that is there.
And the second case, may you said, okay, acquire it, but apply the provisions of 2013, Act
Yes.
of 2013 instead of 1894.
Absolutely correct, my lord.
So as such acquisition proceedings are not under challenge.
My lord, in the
Then
past
why
case,
all these judgments?
my lord, in the first case, I have actually said that, my lord, that should be passed. The acquisition proceeding should be passed.
Cost, sir, you have simply said, 2013 apply,
Uh,
don't apply this act of provisions of Act of
And-
1894.
And-
That's all.
My lord,
You have to go by it.
no, another aspect, my lord, you have also see that whether the subsequent part, suppose in the first part, we said that. Second part, when the position is to be taken, then, my lord, what happens? The Rojanama must be prepared. That is very important, my lord. That is why we have referred to those judgments. Rojanama is very important, my lord. Physical position, unless physical position is taken as per law, no handing over position, symbolic position will not serve the purpose. This is the Supreme Court saying, my lord. Because here our land, my lord, the main thing is this, my right to property has been violated, my lord.
Sir, we understand that we are, maybe your concern is genuine.
Yes.
But ultimately, sir, 226 now. If we direct
No, my
all
lord.
these things,
My
sir,
lord, here lawsuit see whether my land can be landlocked. Now, I have made an alternative prayer also now here, my lord, because they have made some arrangement. We have two plots of land on the right side as well as on the left side.
we understand, we are not saying that your concern is not genuine. The concern is genuine, but ultimately, sir, 226. there are some
226, my lord,
limitations. How
this-
can they,
The 300A, my lord, my 300, right of 300A. My right under Article 300A is violated because it cannot be landlocked, my lord. The other judgments are very much clear, my lord.
for that, you can very well approach the civil court for this right to way, right of way, you can very
My
well
lord,
say.
civil court will not, my lord, civil court.
The 226 is not the medicine for
My
all
lord,
the
if your lawsuit will see, my lord,
problems.
my lord,
It's
in
not the only
In the
medicine for all
readable
the
333, if your lawsuit will see, my lord, they have made a statement, the affidavit also, my lord, that they will make it. My lord, if your lawsuit see
Yes,
page
what-
133,
What statement there?
my lord, in their affidavit.
56, right?
Readable 333, at page 133, they have said, my lord, paragraph 11, that as such, the portion of the land following the proposed emergency exit road can be shifted by 15 feet within the same dark numbers and pattern numbers of the land acquired. Thus, in which case, an approach road shall become available to the referred landlocked piece of the land belonging to the prisoner.
What is taken? 2017, 2014, 43. 143 is my, again, 2021, the petition. It's
Then-
143.
That was the main fact, my lord. 133, paragraph 11, page 133. Because this honorable court has that you should make compromise, because you cannot make the landlocked. Then at page 143 also there, at page 143, another affidavit.
2021. 23 to 2021. Again, take it in. 25.
Now, page 143, if you'll also see, my lord, the second subpara, line about 4. As such, the portion of the land falling in the proposed emergency exit road can be shifted by about 15 feet within the same tag number and pattern number of the land acquired. Thus, in which case approach road shall become available to the referred landlocked piece of the land belonging to the petitioner.
Then what about
My lord, thereafter they refused, my lord,
these read, however it is to be stated that.
my lord. And this is the,
When such proposal was forwarded by the senior official of the IUCL, the petitioner did not agree to the same and approach the road.
my lord, that is the, my lord, that is the main thing, my lord. Can it be done? My lord, they have forcefully taken the portion of the land. State authorities have not taken over the portion of the land. No, Rojanama has been prepared. They have to prepare the Rojanama, my lord, first. 101. We have to file an FIR, my lord, 101, page 101, because they have taken forcible possession of land. At page 101 of the readable 133. So this is the question, my lord, here. My lord, my right to property has been taken away. That is why, my lord, I am referring to another judgment also, my lord. That in the list I have given it. 2013 for SEC. MOU also prepared, my lord, in this regard. MOU is also prepared. Well, if your lawsuit see, if your lawsuit see the mediation report, page 26, my lord, The entire, map has been given, my lord. My lord. In paragraph, 13, it says that access to the land comprising document number 783,
Paragraph 13 of what?
my lord, mediation report, my lord,
Huh?
mediation report.
Yes.
They have said, my lord, that there is no, my lord, even government has also, my lord, filed affidavit that lands are landlocked. There is no road. They have kept it, my lord, virtually. Later on, my lord, they denied it.
Yes,
Initially, they have kept it, my lord.
Mr. Chaudhary. Yes, what proposal you have 133 page number?
My lord, at one point of time, my
Huh?
lord, at one point of time, my lord, some officers became, my lord, considerate towards them and gave a proposal
Ah.
that if we can shift this, and they did not agree thereafter, my lord.
Okay, now if they agree to this proposal, then
No, my lord, in fact, what happened thereafter, now, after this, my lord, we have developed that POL thing, my lord, the entire road is, my lord, now walled.
huh?
The entire road is wall, entry road, my lord. That is primarily the entry road where they are allegedly affected. That has been, my
Raise the
lord, completed,
construction and all.
my lord.
You have raised the construction there.
Yes, my lord. This is wall.
No, no, no. There is no parking.
No, this is a
Parking, it is
complete
a parking. It's a parking place.
compound wall has been erected, my lord, and it is functioning.
Just a- these proposal which you have given to them
Right.
and they deny and they have not accepted it. This proposal can be now be if we accept that
Now, my lord,
at present.
now, my lord, my submission will be, my lord, the interface of the Indian Oil Corporation is with the government. Although, my lord, we had given some,
Your, what we are saying is para number 133.
Yes.
What your, this page number 133, para number 11.
my lord.
Yes, at that time they were not agreed to it, but now if they agree that.
My lord, for that agreement, my lord, the government has also to agree, my
Then
lord.
consider you, is this position still exist or not?
My lord, this option,
This position still exists or not, the government will agree or not, will take care of that.
my lord,
Just come to this.
I can take instruction from that, my lord.
Take the instruction.
I can take instruction.
Yes,
They have sent MOU also, my lord, in this regard to us. Copied them all.
you have not agreed to.
No, not, we agreed, but subsequently this field, my lord, page, my lord, 111, my lord,
You just let, file an affidavit.
yes.
Given affidavit, get this para number 11, what they proposal they
Well-
earlier offered, we are ready to accept.
My lord, I am giving.
File an affidavit.
Yes, within a week, my lord, within,
Then we'll ask them.
my lord.
Based on
Today,
6th of May,
my lord.
by that time, file an affidavit.
No, if they file the affidavit, my lord, then we can obtain the instruction on the basis of that affidavit.
Without even filing of affidavit, you complete
Right.
your instructions.
Right.
My lord,
To bind him, we are asking him to give an
can
affidavit.
it be, my lord, my train will not be there on 8th of May, my lord?
Sixth.
Or 2nd of May,
Second of May.
2nd of May, my lord.
Second of May.
Only for this. We can file it immediately, my lord.
First May,
First May,
Yes,
yes,
yes.
1st of May.
First of
uh, this petition number. 5956 of 2000. An affidavit was filed. An affidavit in opposition was filed by the IUCL. Wherein IUCL in para number 11 of it said affidavit in opposition. It is mentioned that the IOCL has suggested has offered, has gave an offer to the appellant Deepak Damani and others that the portion of the land falling on the proposed emergency exit road can be shifted by about 15 feet within the same DUG numbers and patta numbers of the land acquired. And in that case, an approach road shall become available to the referred landlocked piece of land belonging to the appellants. It is further stated that the said offer was not accepted by the appellants. And therefore, the same, the said arrangement could not be materialized. So, today, Mr. Sahiwala has submitted that now the appellants, Deepak Damani and others are ready to accept the said offer given by the IOCL as mentioned in para number 11 affidavit, para number 11 of the aforesaid affidavit opposition. So, Mr. Sahiwala, please time to file an affidavit of this effect, additional affidavit of this effect of the petition of the appellants in this writ appeal. Based on 1st of May 2025. You, Mr. George.
Hello. Always.
So earlier you referred, gave an offer. Now we'll do that. The problem.
Item number 6.
Lordship, before my senior staff's lordship, they filed an additional affidavit yesterday.
In the morning they.
Yes, yes,
I
lordship.
think your lordship is not aware. I was just sitting around here. There is a news, there's a bomb threat in the High Court. I think all the police squad has come across. That's the squad. That's what, I don't know. That's why I thought I should. Also, I was sitting behind back. So that news,
What he will get after placing a bomb in the High Court?
I don't know.
Yeah. So for the petitioner, place some time to file counter to the reply. Counter to the affidavit filed, latest affidavit filed on behalf of the respondent number 6,
Four, lordship.
Four.
respondent number 4.
Your lordship has recollect, that's for the affidavit, that whether it is an expansion of the earlier
Extension of
2000.
that and yes.
Yes, whether it was expansion, so we have brought that 2006 and we are saying there's a separate unit altogether.
That day we have asked for.
Yes, yes, so we have brought into notice.
Lordship, let us take some instruction.
How much time?
2 weeks, lordship. Much obliged, lordship. Highly obliged.
Item number 7.
May I?
May I please, your lordship?
Yes.
May I please, your lordships? Your lordship, in this case, my lord, the petitioner herein is not a guarantor, mortgagor, or a borrower to this case. My lord, when the construction was, permission was obtained by the respondent number 6, a flat was booked in this case, in that premises in 2013, my lord. An agreement was executed to that effect. Yes, my lord. So accordingly, in 2013, my lord, the flat was booked, and in 2015, we got the possession. And just before the execution of the sale deed, my lord, the respondent number 6, being the owner of that land and building, mortgaged that property with the respondent number 1 bank, my lord. Now, at the time of creation of that mortgage, my lord, that with respect to creation of security interest, my lord, that was the question your lordship has put me on the last date also, your lordship. Only a certified copy of the title document was deposited with the bank, my lord. Now, importantly, while creating a security interest in the property, my lord, it has to be done through the original paper to be deposited with the bank, my lord. Now, importantly, my lord, only a certified copy of that property was deposited, my lord. This is an important point. Why, my lord? Because the security interest was created in two phases. First, the land. The land was created by deposit of a gift deed, my lord. And later on, a letter was executed being a LTR 21, my lord. That is a non-testamentary document, my lord. That is an important point. Why? Because, your lordship, the Registration Act says that the registration of a non-testamentary document with respect to mortgage is also to be taken, my lord. Only importantly, my lord, while creating the security interest.
Have you gone through the recent judgment of this court regarding the security interest?
That is, I have not.
Then come.
Yes, my lord, I'll just go through it.
Observation in my case.
Yes, yes.
I think it has gone to Supreme Court. There is an observation made by the Supreme Court. That this observation, which is in for security interest, that was my lord, not interfered. That the court said that no security interest, respect cannot be in respect of, kindly see this judgment. I thought that I will place it. They made an observation. This was left open to the DRT to agitate this point and observation. Yeah. No, no. No. Any observation that has been made. No, the point was that, my lord, if this is the, because your merit, your lordship has decided. Now, suppose I go back to the DRT, that always will be taken into account by DRT, saying that this is.
Yes, they can, these are the, ultimate.
That's the only
Already been decided.
That's what, that's nothing more, nothing less, my lord. That jurisdiction part. That jurisdiction part, of course, it is before the DRT, my lord.
It is very, the order is to be read in very, shall not be conclusive insofar as parties in this list are concerned.
Yeah.
And not in overall.
No, what, no, the apex court,
in relation to the parties, they have DKK, but otherwise they have not interfered.
No, there is no question of interference. That was that, yes.
The party.
It is only the security interest. Agreement for sale. But section 54 has been, my lord. But ultimately, section 54 has been quoted by. Not only the difficulty was there, absolutely this court doesn't have jurisdiction below DRT. Only difficulty is about the observation, my lord. Because ultimately they may take it.
If the Supreme Court has said these are not conclusive,
That's
for
why,
all the
that's why.
cases, then it would have been
No,
different thing.
No, that is why.
So far as the parties in this list are concerned, अब क्या वहाँ पे argument हुआ होगा, क्या है, that
No, that is, I was just telling the lawyer who argued this matter, what was the reaction? Like he said, it was argued before the court, but court didn't want into the entire merit of the case to be got. HDFC, the caveator was also there. I said, whether caveator, then they said, caveator, please do not say anything, the caveator. Because otherwise we have to write a lot of things. We don't want. Let it be decided by DRT. Any observation, only what was worriness.
you go through this judgment and then come.
Yes, I think, yes.
Lordship, with much apology, your lordship. Lordship, matter number 6, there is an interim lordship that may be continued till next step. It's interim order.
I have one matter, my item number 10 to 12.
Item-
10, my 11, 10, 12, my 10 to 12, Mr. The government is there.
Yeah.
So if it is not inconvenient, can it be any other date, my lord? So my learned friend, Mr. Rajiv is here. Ten to 12, right?
Lord, 11 I am.
my lord. On affidavit on file for 240. On affidavit also, they filed, just yesterday I was reading, there is no reply filed by us in 240. They filed an affidavit. So if your lordship can allow me, hearing has not taken.
It's always open.
Yes, that's why I taken leave of the court, that affidavit. If your lordship allow me to file affidavit in reply.
There is a requirement for this, leave of the court.
No, just because 4, 5 months, 6 months back, I was a bit annoyed, 6, 7 months. I didn't go also. It should have been filed immediately.
A request is made on behalf of the parties to adjourn these matters. Full stop. I will learn a concept for the parties to adjourn these matters. Matters are adjourned, however, this is in August 2025. However, in the meantime, the parties are free to file additional pleadings if required.
I am deeply obliged, deeply obliged.
But may I pray for a date, my lord, in the month of June, my lord.
No, August.
We have urgency, my lord.
You have urgency. That's why only in August, otherwise we would have posted in 2026.
Then we have prepared for today.
Earlier-
We have prepared the matter.
Item 9.
Earlier, there was case where rule was issued. Your lordship, where rule is issued after 3, 4 years. Now your lordship,
Is now
May I pray for it?
2024 cases are.
yes.
But may I pray for a fixed date subject to my lord's continuation?
August, man. Ask the registry, otherwise what the registry will do.
I am deeply obliged. Sir.
Item 9.
Yes, these are the, some of the orders if you.
Lordship, otherwise, Lordship, as per notification, circular number 9 of 24, it is below the threshold limit. Now, the only thing, my lord, as of now, my lord, we have not received instruction whether to withdraw it or.
Okay. Having taken into consideration the fact that amount involved in the present case is below the monetary limit of rupees 2 crore. This central excise appeal.
Income tax appeal.
This ITA, income tax appeal, is liable to be dismissed as per the national litigation policy in view of the instructions dated 17th of September 2024, issued by the Central Board of Direct Taxes, Ministry of Finance, Department of Revenue, Government of India. Ordered accordingly. However, the question of law raised in this appeal is left open for appropriate decision in appropriate case.
Deeply obliged.